Hey guys, welcome back to another video. Now, as y'all see by the title, we're going to get into Drew Dixon versus A.Reid opinion in order. This was recently filed on the 21st of August, 2025. And if anyone has been following me, especially on X, formerly known as Twitter, when I first started my channel, or my page, I did started to cover this case. Now, there's been dozens upon dozens of other cases that has come about since then, and this case has pretty much been on the back burner for me. And we're going to get back into some things, so much as far as what's going on with this case, simply because of the fact that trial is approaching. Okay. And as y'all can see by the bottom, let's go ahead and get into it. So, copyright disclaimer: I am simply saying that I'm not an attorney, I am not a paralegal, and I'm not a judge. I'm just simply saying that I know how to read. And today we're going to get into the opinion in order. So let's go ahead and get into it. As y'all can see here, this is the opinion in order that was filed, as I just mentioned. So the defendant is A.Reid and the plaintiff is Drew Dixon. So let's get into some things, y'all. Defendant moves to preclude the testimony of plaintiff's expert witnesses, Michael Salvern, Mark Plotkin, and Dr. Titra, or Citra, however you want to say it, Rockland, pursuant to Federal Rules of Evidence 702 and 403. So ECF numbers, that is letting you know the docket number. So that's docket number 115 and docket number 122. For the reasons set forth below, the motions to preclude are granted in part and denied in part. Okay. So we're going to get into some things. So it is 17 pages here. So I want to get into the background. As y'all can see here, it's a brief background going over the actual complaint. And I do have the original complaint. I will have that in the description box below. But for y'all who are new and don't know what's going on, we're going to go ahead and read this part. And then we're going to go down and see what was the reason that they approved in part or granted in part and denied in part. Okay. So this is Dixon. Plaintiff alleges that from 1996 to 2002, she was employed as an A&R executive at Arsta Records. Plaintiff's employment agreements contain an A&R bonus provision, which provided that plaintiff would receive commissions as a percentage of Arsta's retail sales revenue for artists who, during your full-time employment by us, enter into recording contracts with us primarily because of your efforts. In 2000, and defendant is A.Reid, became the president and CEO of Arsta. Plaintiff alleges that between 2000 and 2002, defendant sexually harassed her by, among other things, making flirtatious comments and frequently calling her late at night to ask that she join him in his hotel room, and then becoming angry when she would not relent. Plaintiff alleges that defendant sexually assaulted her on two separate occasions in 2001. According to plaintiff, while she was working at Arsta, she and another colleague brought Kanye West in for audition, but defendant decided not to sign him. Plaintiff also alleges that while she was working at Arsta, she attempted to bring John Stevens, who performs under the name John Legend, to Arsta. Plaintiff alleges that defendant failed to attend a performance by Legend, and plaintiff ultimately was unable to offer him a deal. Dixon departed Arsta in 2002, leaving the music industry to pursue a degree at the Harvard Business School. Okay, so we're going to go back to the top. As y'all can see there, defendant moves to preclude the testimony of plaintiff's expert witnesses. So we have three people that he wants to preclude. You have Michael Silvern, Mark Plotkin, and Dr. Citra Rogvan. Okay, so we're going to get into their actual findings, testimonies, that that nature. So it starts off with Michael. So let's get into Michael. Okay, Michael Silvern is an attorney who, for the past 39 years, has specialized in the field of executive compensation in the music industry. Over the course of his career, he has represented artists in their contract negotiations for recording and performance agreements. Record executives in their negotiations of compensation packages with their employers, and music labels in their negotiation with executives. In connection with this litigation, Salvern submitted an expert report setting forth his opinions regarding plaintiff's lost future compensation. In rendering his opinion, Salvern reviewed Dixon's compensation package during her time at Arsta. Salvern noted that plaintiff was hired in 1996 as a senior director for a 2-year term. She earned a base salary of $90,000 and a $10,000 signing bonus, plus the bonus plan for any artist that plaintiff was responsible for bringing to Arsta. In 1998, her term of employment was extended for another 2-year term. Her base salary was increased to $175,000 with 2 annual increases of $25,000, and she received a signing bonus of $25,000. Plaintiff was also promoted to the position of vice president when one of her designated artists' albums sold 500,000 records. As y'all can see there, 500,000. So Vern appends that the improvement in her compensation package and title in such a short time span indicates that Arsta viewed plaintiff as a budding superstar. So Vern opens that had Dixon been responsible for signing either Legend of West to, they must have meant to Arsta in 2001, she would have solidified her reputation as one of the top talent executives in music. The likely future career path for Dixon would have led to a label presidency, CEO title, or a joint venture or other similar split profit equity agreement. Reviewing the compensation package of contemporaries of plaintiff who rose to the ranks of CEO for major music labels, Savern concludes that if Dixon had continued along the trajectory she was on when she departed Arsta, it is highly likely that Dixon's earnings would have reached 7 or 8 figures annually. It is equally likely that Dixon would have created a joint venture with a major record company to see her fortunes rise into the 9 figures. Okay, so that was the first, as y'all can look here, that was the first testimony. Okay, so let's get into Mark Plotkin. Plaintiff retained Mark Plotkin to provide an expert opinion regarding the hypothetical earnings plaintiff would have received from her A&R commission structure had she successfully signed West and Legend. Refer back to docket 114/3. Okay, Plotkin holds a Bachelor of Arts degree from a joint program between Case Western University and the Cleveland Institute of Music and has over 2 decades of diverse experience in the music industry. Plotkin is a member of the Recording Academy, co-founded Decision Desk and Wi-Fi Music School, and is the founder and CEO of Beast Music AI, a media platform utilized by record labels such as RCA Records and Atlantic Records. Plotkin further serves as a professor in the area head of business and technology at New York University's Clive Davis Institute of Record Music. To calculate plaintiffs' loss commissions, Plotkin created a web-based interactive version of his report. Plotkin first looked at plaintiff's employment agreement for the relevant formula, which included varying percentage based upon such factors as domestic versus international sales and the type of income, which is album sales, singles, EPs, and you'll look and you'll see here he just, basically bringing up a few other things. But we're going to skip over that part because that's just him giving an example of the type of income. So it says Plotkin then researched West and Legend's first contracts with Def Jam and Columbia Records, respectively, as well as their sales data year by year to ultimately determine how many records and singles were sold across various mediums and the price per limit. Plotkin Interactive Report all allows the reader to set variables, the durations of time plaintiff remained at Arsta, and West and Legend's respective rates for music royalties and ancillary incomes, which then would yield a commission amount based upon the formula set forth in plaintiff's employment agreement. For example, if Dixon is assumed to have left Arsta in 2010, the music royalties are set at 15% for each artist. Plotkin calculates that plaintiff would have received 6,234,855 in commissions from West and 1,866,584 from Legend. And then it says at 73.74. I'm not sure if that is from the docket or from the actual page. Ooh, excuse me. But let's continue. So let's get now into Dr. Citra Raghavan. Plaintiff retained Dr. Citra Raghavan to conduct a psychological evaluation of plaintiff. Dr. Raghavan is a licensed clinical psychologist with more than 20 years of experience. Go back to docket 120. It says Dr. Raghavan received her doctorate in clinical and community psychology at the University of Illinois at Urbana-Champaign, however you say it, and postdoctoral training at Yale University. Okay, so this is just going over a little background of her. Okay, so we're going to skip down. Now, I will have this court document in the actual description box below so you can read it in its entirety. Well, we want to get into some facts before we see what was the opinion in order, okay? So it says that Dr. Raghavan explains that her opinions focus on the expert to which defendant inflicted sexual, physical, and or emotional abuse on plaintiff sometime between 2000 and 2002 when she worked at Arsta Records as senior director and later vice president of artists in the repertoire. Okay. The mental health consequences that plaintiff suffered as a direct result of the abuse inflicted by defendant, if any, whether the physical, sexual, or emotional abuse and its consequences have disrupted any other areas of plaintiff's life, and 4, treatment recommendations. So it says Dr. Raghavan opines that she found Ms. Dixon's reported history to be believable because she reported a decrease in recent symptoms rather than an increase, a pattern that would be typical to malingerers, however you say that word. Plaintiff's emotional and physical responses were consistent with the experiences she relayed. She was able to clearly explain the abuse, fact pattern, in her narratives over multiple interviews, and 3 objective tests indicated that she responded genuinely about her mental health. She further opines that defendant used numerous tactics of coercive control to maintain his abuse of power over plaintiff, including physical violence, manipulation, sexual abuse, retaliation, and micro-regulation. It says Dr. Raghavan opines that the sexual assaults and the atmosphere of coercion and hostility that plaintiff suffered triggered a severe episode of complex PTSD. It says, 1, Dr. Raghavan opines that it was defendant's sexual assaults and his entrapping, hostile, and coercively controlling behaviors that were directly responsible for many of plaintiff's psychological disturbances. In terms of injuries, Dr. Raghavan detailed the basis for her diagnosis that plaintiff meets the diagnostic criteria of complex PTSD, and major depressive disorder. And then it says she then opens, and then as y'all can see here, Miss Dixon's initial success and later dreams of a career in the music industry were shattered by Mr. Reed's abuse and his actions. As described earlier, Miss Dixon could not advance without Mr. Reed's support, and he would not support her without her giving into his sexual assaults. Protracted betrayal from a mentor and leader in black music followed by his supporters and entourage, and the accompanying injustice harm one's well being in a very particular way. For Miss Dixon, it created a sense of hopelessness, despair, and loss of faith in the world. The shattering of trust cannot be regained easily. Further, the years that Miss Dixon lived with despair, shame, and numbed feelings were essentially painful. That is, from feeling excitement, curiosity, and feeling alive, she felt dead, hopeless, ashamed, and without a future other than caring for her children. Nothing can return that feeling of excitement, aliveness, or delight that Miss Dixon felt daily under Clive Davis. That innocence has been destroyed by the casual cruelty of a determined predator. However, creating appropriate restitution that allows Miss Dixon to at least be financially able to pursue her creative dreams might address a small fraction of her pain. Dr. Rockland concludes that despite her life being hijacked by a selfish, predatory needs of Mr. Reid, Miss Dixon is determined to succeed. Financial reparation cannot return her to her younger self, but it can at least allow her to move forward and protect herself during her most fragile moments. So that is the legal stand that they have of the three witnesses, or as y'all see, title above. So let's look down. Now, again, I'm going to have this at the bottom of the description box so y'all can get into it. So it says discussion. It says where lost future earnings are at issue, an expert's testimony should be excluded as speculative if it is based on unrealistic assumptions regarding the plaintiff's future employment prospects. And as y'all can see, it's cited a different court case. It says the benchmark for any such calculations should be the income earned by the plaintiff in prior years, including median income in the years immediately prior to plaintiff's departure from employment. And as y'all can see there's another court case, okay? Let's see here. It says admitting expert projections regarding future earnings where it was not based on speculation that a future freelance business might flourish, but grounded instead in historical data regarding past earnings. Expert testimony as to lost earnings that is not grounded in a sufficient factual foundation should be excluded. And it says Salvern does not purport to calculate plaintiff's lost earnings based on her actual compensation at the time she left Arsta. Indeed, he does not purport to calculate her lost earnings at all. He does not. For example, specify how long plaintiff would have expected to work in the industry with reference to verifiable statistics regarding longevity in the industry, or even actuarial, or however you say that, actual, however you say that, but y'all see that word. Tables reflecting life expectancy. He does not calculate the value of lost benefits. Ooh, Salvern lack of mythology and reaching his opinion on future earnings, lost and reflected in his failure to quantify such damages. Salvern vaguely asserts plaintiffs suffer damages in the range of millions to hundreds of millions of dollars, but such an opinion is of little assistance to a jury. Salvern's opinion also rests on inherently speculative assumptions. Salvern conjectures that plaintiff not only would have continued to have a successful career in the music industry, but that she would have reached the pinnacle of the profession to become a CEO of a major record label or otherwise enter into a lucrative joint venture agreement. These hypothetical promotions, bonuses, and business deals lack sufficient evidentiary foundation and thus cannot form the basis of an expert opinion. Ooh. Let's see here. It says, so they're going in on Severn. It says, accordingly, Severn's opinions are too attenuated, and lacking the real ability to permit them to be submitted to a jury. His testimony is excluded in its entirety. Ooh. In contrast to Severn, Plotkin's expert opinion does not, it says it does include specific calculations produced pursuant to an ascertainable methodology. Plotkin's expert report set forth in detail each step in his analysis, as well as all data inputs. It says defendant, for the most part, does not challenge his calculations or his methodology. Defendant does take issue, however, with Plotkin's use of historical data regarding record sales as the basis for his opinion. Defendant argues that the use of such data renders Plotkin's opinion unreliable. It rests on the faulty assumption that West and Legend would have released the same albums while at Arsta and thus earn the same revenues. Yet these are the types of assumptions that go to the weight of the evidence, not admissibility. The use of historical data may not provide exactitude, but allows for calculations to a reasonable certainty, which is all the law requires. So it says any calculation of future earnings is to some extent a predictive exercise, subject to a degree of uncertainty. How long would a person have worked? How long would they be expected to live? How long would they have stayed at a particular job? Would they have been promoted or received bonuses? Would they have been subject to layoffs or medical crises that would have limited their earnings? Would they have changed their careers at some point in the future? That future events is inherently unknowable, and it does not mean future earnings are unrecoverable. Rather, the uncertainty highlights why courts insist that any such calculations be grounded in a sufficient factual predicate to ensure that damages can be reasonably estimated. Okay, so we're gonna skip over that. It says Dr. Proposal testimony. It says, okay, so let's get into Dr. Raghavan. It says the Second Circuit has made clear that the credibility of witnesses is exclusively for the determination by the jury. A witness may not open as to the credibility or the testimony of other witnesses at the trial. Even expert witnesses possess of medical knowledge and skills that relate directly to credibility may not state an opinion as to whether another witness is credible. Although such witnesses may be permitted to testify to relevant physical or mental conditions, as you can see here, they're quoting a particular case. It says this court, echoed by our sister circuits, has consistently held that expert opinions that constitute evaluations of witness credibility, even when such evaluations are rooted in scientific and technical expertise, are inadmissible under Rule 702. Consistent with this principle, in cases involving allegations of sexual assault, an expert cannot testify that the defendant is, well, in fact, sexually assaulted the plaintiff or vouch for the victim. Dr. Wakavan's anticipated testimony is replete with improper opinions regarding witness credibility and bolstering. Plaintiff seeks to offer into evidence Dr. Raghavan's opinion that she found Ms. Dixon reportedly history to be believable. It says her expert report describes the defendant as a determined predator whose casual cruelty destroyed plaintiff's innocence. Dr. Raghavan's opines that defendants exercise coercive control over plaintiff through such tactics as physical violence, manipulation, sexual abuse, retaliation, and micro-regulation. She opines that defendants' sexual assaults in his entrapping, hostile, and coercively controlling behaviors were directly responsible for many plaintiff's psychological disturbances. It says such bolstering testimony regarding the truth of the underlying factual allegations in this case is not the proper province of an expert witness. Ooh. And so now let's see here. They're getting to the plaintiff argue. It says plaintiff argues that Dr. Rockvan's testimony is akin to the expert whose testimony was permitted. And then y'all see they quoted another case. But if anything, that case further undermines her position. It says the expert I'm getting tongue tied. Psychologist, y'all, diagnosed plaintiff with PTSD and opined that her PTSD was consistent with a person who suffered sexual assault. And that's another case that they quoted there. The expert did not offer any opinion that sexual abuse caused plaintiff psychological conditions. In holding that this testimony was admissible, the court differentiated it from testimony that risks invading the province of the jury by impersonally vouching for the credibility of the plaintiff by opinion that plaintiff's allegations are credible or that the expert believes the plaintiff. That case stands in stark contrast to this one, where Dr. Rockvan does seek to testify as a credibility in causation. Plaintiff also points out, so we're going to skip over that. Okay, so, well, maybe we need to read. Well, hold on, let me see this part. Accordingly, the court holds that Dr. Rockvan is precluded, pursuant to Rule 702 and 403, from offering testimony at trial regarding plaintiff's credibility, including an opinion that plaintiff was the subject of a sexual assault by defendant, or that defendant exercised coercive control over plaintiff. She is also precluded from opinion on the causation of plaintiff's conditions. Dr. Rockvan can testify, however, as to coercive control generally, as background, her diagnosis of plaintiff's mental health conditions, and the basis of her diagnosis, and that plaintiff's condition is consistent with that of individuals who have been sexually assaulted. So it's saying, for those reasons stated herein, defendant's motion to preclude the testimony of Michael Severn is granted. So it's saying that his testimony will be thrown out. The motion to preclude the testimony of Mark Plockton is denied. The motion to preclude the testimony of Dr. Rockvan is granted in part and denied in part. Okay, we just read that piece right here. So there you have it, y'all. Now, I would have this on my X page, and I will have it in the description box below. Now, if you like what you've seen here, like, share, and subscribe. And until next time, I'll see you soon. And as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. Take care.
Oh, stepping man chance. Step in the court, I'm the eyes and the ears. Dropping the facts, no rumors in here. From the filings to the rulings, I'm spilling the tea. Every dog, every line, yeah, it's all from me. You want receipts, I got the page. Breaking it down, center stage. From subpoenas to them big appeals. Document Tingz, we keep it real. Yeah, Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. It's Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. No cap, no spin, just the ink on the sheet. From civil to criminal, I'm bringing the heat. When the gavel come down, I'm writing the note. Giving you the story from the filings that show. Contempt or appeal, I'ma let you in. Settlement talks or a jury win. Public records, private fights. Document Tingz, keeping days and nights. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Document Tingz, bringing truth to the light. Paper trail strong.